Hi, good evening everybody. My name is Carl Arbuthnot. I'm a human rights officer and project coordinator at the Sikh Human Rights Group, an NGO or non-governmental organisation with special consultative status at the United Nations. And I'd just like to thank you all for attending this online event regarding the current criminal bar strikes. We have a plethora of experts with us today. First and foremost, Mr. Jo Sidhu QC. Jo was the chair of the Criminal Bar Association from 2021 to 2022. He was also formerly the president of the Society of Asian Lawyers. He graduated from Oxford with a degree in politics, philosophy and economics and completed his master's in international political economy from the London School of Economics. Called to the bar in 1993, he was appointed as Queen's Counsel in 2012 and was made a bencher of Lincoln's Inn in 2014. Over the last 3 decades, he has appeared in some of the country's highest profile criminal prosecutions in offences of murder, terrorism and fraud. For many years, he has pushed the drive for greater diversity within the profession and amongst the judiciary. He has served as Vice Chair of the Bar Council's Equality, Diversity and Social Mobility Committee and continues to undertake extensive work to make the bar accessible to the widest range of entrants. Also with us today is Miss Lucie Wibberley. Lucie was born and raised in Sheffield and attended an inner city comprehensive school. She completed an undergraduate degree at the University of Brighton in Humanities, achieving an award of first class, followed by an MA in political philosophy at University College London before converting to law. Lucie previously worked in politics at constituency level for several years at Westminster, working for Labour MPs under the Blair administration, for the charity Inquest in relation to deaths in custody and a solicitor's firm specialising in election law. She was called to the bar in 2005 and has a defence-only criminal practice at Garden Court Chambers, where she specialises in serious crime, including homicide, firearms, gangs cases, fraud and complex organised crime. Recent high-profile cases include that of Sally Challen, who successfully appealed her conviction for murder of her husband, and R versus Norman, a prison officer convicted of misconduct in public office after he leaked public interest stories to the press, who appealed his case to the European Court of Human Rights. Combining motherhood and her practice in criminal defence, Lucie has continued her political work, speaking and writing about policy issues that impact the criminal courts. She was instrumental in the successful fightbacks against the implementation of extended operating hours in the criminal courts, chairing the Criminal Bar Association's working group, which published a report incorporating an analysis of why the proposed policy was discriminatory against women. Lucie is a long-term campaigner on improved working conditions in the criminal courts and presently Secretary of the Criminal Bar Association. Consequently, she is instrumental in the action currently being undertaken by the Criminal Bar to achieve a fair settlement in relation to legal aid fees, in order to save the criminal justice system from systematic collapse. She is speaking tonight in a personal capacity. Also with us today, and last but not least, is Ruba Huleihel. Ruba is a second crime pupil at Pump Court Chambers. She has worked as a paralegal in criminal defence, community care and immigration. She holds an LLM or a Master's in Law in International Criminal Law. Before pupillage, Ruba was a legal advisor at Harrow Law Centre, working with young people and parents on stop and search rights, county lines exploitation, education law and community care law. Alongside this role, she was a support worker to Syrian refugees at Single Homelessness Project. While on the bar professional training course, Ruba was a volunteer advocate in school exclusion hearings with Communities Empowerment Network and taught debates in Her Royal Majesty's prisons, Wandsworth, Isis and Pentonville, with Gray's Inn vocalised. Before studying law, Ruba co-founded an ethical fashion brand employing women facing barriers to work. She's also worked with Seeds of Peace and Solutions Not Sides, conflict resolution charities focused on the Palestinian-Israeli crisis. So now turning to the criminal bar strikes themselves. On Monday, the 5th of September 2022, barristers across England and Wales began their indefinite uninterrupted strike action in an escalation of industrial action over legal aid rates, which began in April 2020. The walkout marks an escalation in tensions between criminal barristers and the UK government as they fail to agree on what is an acceptable level of pay for legal aid work. For those of you who don't know, it is important to note that the UK government currently decides what criminal barristers get paid when defending those who qualify for legal aid. Nevertheless, following government cuts between 2010 and 2014, an independent review of criminal legal aid published in December 2021 concluded, and I quote, that their central recommendation is that the funding for criminal legal aid should be increased overall for solicitors and barristers alike as soon as possible to an annual level in steady state of at least 15% above present levels, which would in broad terms represent additional annual funding of some £135 million per annum. The government responded by accepting the independent review's recommendation to pump an extra £135 million a year into the criminal legal aid sector, and later in 2022 announced that it would increase the fees by 15% in September 2022. The Criminal Bar Association, however, wants a 25% increase from the government, arguing that with inflation at around 10%, this means that a 15% rise in fees will be more than extinguished by the time it reaches criminal barristers. The Criminal Bar Association has also stated that there has been an average decrease in criminal barristers' real earnings of 28% since 2006, with average earnings from legal aid collapsing by 23% during the pandemic. Consequently, industrial action was first taken back in April, when criminal barristers stop accepting returns, where a barrister will fill in for another barrister who cannot attend court, usually due to a diary clash. At the same time, the Justice Secretary, Dominic Raab, labelled this decision by the Criminal Bar Association unnecessary and irresponsible, linking barristers to strike action to court delays. Barristers then staged a series of escalating walkouts for 4 weeks from the 27th of June 2022 unless a deal was reached. These strikes were coupled by allegations that Dominic Raab had requested the names of striking barristers to be provided to the Ministry of Justice following reports by the Law Gazette that Crown Court clerks had been asked to record daily data regarding non-attendance, including those who do not attend court owing to strike action. So with this build-up of distrust between both sides and no side of agreement in sight, criminal barristers who had before this year only staged a day-and-a-half walkout back in 2014 are now at the beginning of an indefinite uninterrupted strike. However, for barristers, this is not just about pay, but also about the current state of the criminal justice system of England and Wales and the future of the criminal bar. So with that being said, I would now like to turn to the first of our questions for today's panellists, which is, panellists, for members of our audience who have very little understanding of life at the criminal bar, in your expert opinions, what factors, both professional and personal, have led to this indefinite strike action? And Mr. Sidhu, if I could ask you to go first.
Thank you very much, Carlos. I hope I can be heard reasonably clearly. Can I start by thanking the Sikh Human Rights Group for taking this subject on? I think it's really important, not just because it's an issue which is very much in the public eye these days. There's been a huge amount of media coverage about barristers going on strike, a rather unusual phenomenon. So most people found it a bit peculiar to see people in their wigs and gowns outside court rather than inside court. But it's really important, I think, from the Sikh Human Rights Group's point of view, to highlight these sorts of issues, because the effect of this barrister strike, obviously on those who are involved in the criminal justice system, goes far and wide and beyond individual courtrooms. It's really about the role that we play within society more broadly as advocates, both for the state and against the state. Those of us who prosecute and defend can play either of those roles, and many barristers, in fact, perform both at different times. This has been a dispute with the government, which has been brewing for quite some time. As you've given us a very helpful history, Carlos, of the way we have arrived to where we are now, I don't want to cover the same ground, simply to address your question in the following way. There are indeed professional and personal reasons why thousands of barristers made a very difficult decision, which was to withhold their labor, something that had never happened before, and certainly not to the scale that we are now seeing up and down the country. This is a difficult decision because those of us who came to the criminal bar self-evidently were not motivated by money. Had we been motivated by money, we would have chosen different areas of law to practice in, which were far more lucrative than criminal legal aid work. This is the poor cousin of the justice family. This is the area of work that people come to because they're driven almost exclusively by a deep sense of public service. They are not motivated by what they can earn. They are motivated by the impact that they can have on people's lives, and whether that means representing a victim as a prosecutor or a hapless defendant who needs a voice in court, it comes to the same thing. We as individual criminal barristers have a role to play in ensuring that the criminal justice system more widely performs the role that it's meant to perform. The problem we have, and the reason why we are now on strike, is because the system has manifestly failed to deliver what it should for the British public. And what do I mean by that? Well, what I mean by that is that the government, and it's not just this government, but previous administrations as well, have repeatedly and unforgivably failed to invest properly in the system. That means failed to invest in the capital infrastructure that is part of the court system. That means court buildings, the technical equipment, and everything else that keeps things ticking over. It's equally failed to invest in the human beings who run that system. That's us as criminal barristers doing legal aid work, and it also involves criminal solicitors who themselves are participating in some limited forms of support for what we are doing. It also means all the court staff, the people who run the courts on a day-to-day basis, your court clerks, your court ushers, the administration, and everybody else. Every single part of the criminal justice system has suffered in consequence of underfunding. It was once said by Sir Brian Leveson that you must understand the justice system as an ecosystem. So if one part of the system begins to fail and atrophy, so it impacts other parts of the system as well to their detriment. So if we don't pay people enough money to do legal aid work, that will have an impact on the way in which the system runs overall. And we're seeing it quite clearly over the last number of years. Let me simply illustrate for you what is actually happening and why we've been driven to this position. Right now, there are about 60,000 cases in a pipeline in the Crown Court system. That's a 60,000 cases workload, which simply cannot be budged. And the reason for that is because we simply don't have enough human beings servicing the system. The Lord Chief Justice himself made the observation that the reason why we are stuck at the moment with this huge backlog is not because we don't have enough court buildings available and open to hear cases, but because we don't have enough barristers who defend and who prosecute, and we don't have enough judges to hear those cases. That is not something that has arisen by accident. That is something that has arisen as a result of deliberate policy decisions taken by government not to fund this system adequately. And so whenever any of you hear government saying that the reason why we have this crisis is because of the pandemic, you can put that largely to one side. Before this crisis reached the culmination that it has today of 60,000 cases, there were already a backlog of 41,000 cases in the system in March 2020. That's before the pandemic impacted our courts. Since that time, of course, the backlog has grown, but it's also grown because of another critical factor. And it's this: we've lost about a quarter of our workforce in criminal legal aid work over the last 5 years. That's 25% of the human beings who run the system have decided that you can't do this job any longer. Last year, we lost about 300 individual members of the criminal bar. Now, given that we only really have about 2,400 specialist criminal advocates left in the industry, losing 300 in 1 year is quite a sizable number. But particularly at our junior end, where we've lost 40% of our criminal juniors who are doing this sort of work because they couldn't afford to pay their bills any longer. And I'm afraid this is what good old-fashioned market forces creates when you don't pay people enough and people elect to respond by voting with their feet and moving out of criminal work and into other areas of legal practice, and indeed out of the bar altogether. We therefore have a veritable crisis, and it's not a crisis that's going to be resolved overnight. But one of the key levers that the government could pull in order to ensure that we get over this crisis and start to work again and start chipping away at that backlog so we don't have victims and defendants languishing and waiting for their day in court is for the government to pay us properly. Now, I've been focused as the chair of the Criminal Bar Association very much on the juniors in this industry, the juniors who have, as a median income in the first 3 years of their practice, only been earning £12,200, which if you convert that into a 40-hour week is about £6.25 an hour. That is considerably below minimum wage. And it's those juniors that we have to have an eye on, because if they don't stay doing criminal publicly funded work, then we won't have a diverse cohort of barristers, we won't have silks of the future, and we won't have the judiciary that represents society as it needs to in order to retain public confidence and faith. And so this has been, in fact, an existential battle. It's for the existence of the criminal bar doing publicly funded work. And that means ensuring that there is a fresh supply of new people coming into the industry from the bottom end who have belief that they will have a viable career in the future. So to answer your question, Carlos, as to why we've got here, what are the professional and personal reasons? They are to do with the structural demise of our criminal justice system. They are to do with the sense of despondency and despair amongst those who practice in this area of work, notwithstanding their sense of public noblesse oblige. And they are to do with government failure to invest properly that will ensure that we're on a sure footing going into the future. These are the actual reasons. That's why 91% of barristers in our last ballot, which was announced as a result on the 22nd of August, favoured taking strike action of one form or another, a drastic thing for us to do. And you can only imagine we must have been pushed to our extreme limits to have to decide to take such a difficult decision. Thank you, Carlos.
Thank you very much, Jo. Lucie, I don't know if you have anything you'd like to add to that.
Well, Carlos, first of all, I would like to adopt and endorse what Mr. Sidhu has said about thanking the Sikh Human Rights Group for inviting us on and giving your focus and bringing your perspective to this really important issue. And so with that in mind, rather than going back over the points that Jo has made, let me just see if I can drill down with a slightly different angle to the question that you have posed, the really important one. What has brought us, what has triggered the action that we're taking? And I would give, I think, 3 subheadings to the answer that I would give in response to that question. They are these: number 1, economic; number 2, democratic; and number 3, it's about diversity. And let me explain what I mean by that. Jo has really, I think, explained to you the chronic underfunding that has pushed the most junior in our profession into a position where they can't continue to work. When you've only got 2,400 criminal defence specialists left in the jurisdiction and 300 left last year alone, you know you're into a crisis. And that's why we can't service the backlog. It's why we're now at 60,000 cases and increasing. People can't work for £12,200 a year and survive, particularly not if they're from backgrounds like mine, ordinary working class backgrounds. So economic is what is the primary reason that has precipitated this into the action at this juncture. But you need a perfect storm, don't you? For professionals to be pushed to take such extreme action, you need a perfect storm. And so the second heading that I would give in answer to your question, which I think Jo touched on there, is democratic. Thinking about the important role that we play within civil society, maintenance of the rule of law. You can't have a functioning democracy if you don't have functioning courts and you don't have a legal system that is fair for the people that are being brought before it and fair for those who are bringing their grievances in front of it. I mean, that's your Article 6 right. And I think we as professionals, being true to our calling, true to our vocation, are not just motivated by the fact that we can't see a future for our juniors if we continue to see them financially exploited by government, but that we can't in good conscience continue to participate in a system which is no longer able to, because of chronic underfunding, deliver what it promises, which is justice in a timely manner, where those who are accused of crimes and those who are alleging crimes are seeing resolution within a reasonable window, and where both sides have parity of representation. And it's one of the points that Sir Christopher Bellamy touched on in his own independent report, and which motivated him to make the recommendation that he did, that we need an urgent increase in the funding right now, because he was making the point that if we continue as we are with defence fees as they are, you're starting to reach a system where you're tipping the scales of justice in a way that may go on to impact the actual systemic fairness of the very system we're trying to preserve. So I think democratic had a real motivating factor in all of this. It certainly did for me, in terms of no longer being willing to participate in something which we could see was in danger of collapse. And then finally, diversity, and by that I mean primarily racial and gender diversity. We are but a microcosm of society, and so, as with any profession, we reflect the structural inequalities that you find, and so inevitably so you see that in the rates of pay. I think there is now a generation of us working our way through the criminal courts who again are feeling that there is an element here at play where you have got just at the point where you have a diverse cohort moving through from the most junior ranks, you similarly lose them at around the 7-year core mark, because they can no longer retain their stake in the thing that has been promised to them, which is an effective and satisfying and rewarding career, doing the thing that they have a vocation to do in order to serve the society. And there is such a palpable sense of unfairness about that. Having been told, as I have for the 15 years that I've been at the criminal bar, that if only we're patient, we will see racial and gender equality at the higher echelons of the judiciary. And frankly, I no longer accept that is right. We will not see it unless and until we're willing to take the action that is necessary to ensure that we carry through those from the bottom to the top, and continue to reiterate time and time again that there is a place for them at the table. And that has to be more than words. We have to deliver it financially, and we have to mean it. So in answer to your question, I think it was the perfect storm of those three factors over a period of around 20 years, and that's how long it has taken, that has pushed us to a tipping point right now.
Thank you very much, Lucie. Ruba, I don't know if you have anything you'd like to add.
Yes, thank you. I'd also like to thank the Sikh Human Rights Group for having me speak today. It is wonderful to be alongside such an accomplished panel, and I'm very humbled and happy to speak alongside you. I can speak from the perspective of the most junior person at the bar, as I'm a second Sixth pupil and I only started taking on my own cases in April of this year. From the perspective of a pupil, most of our work is actually in the magistrate's court, and I would like to touch on that because the fees in the magistrate's court are incredibly low. For a standard hearing, it is £50 for the hearing. For a half-day trial, it's £75. For a full-day trial, it's £150. Now, those fees include preparation, which means as a pupil, it might be the case that the night before your trial or your hearing, you get hundreds of pages that you must read through and prepare. That includes your travel expenses. So it could include a £50 train ticket. And it could include spending a whole day waiting at court because of how things are listed. There is a backlog in the Crown Court. There's also a backlog in the Magistrates' Court. I think the magistrate backlog is between 400,000 and 500,000 cases at the moment. When I have recently prosecuted a list where there were 7 trials listed in the same day, which inevitably means that some people will be sent home and have their trials adjourned. In terms of the pay, you've heard from Jo that the average income for a junior criminal barrister is £12,000 a year. And that comes after debt from studying for years. When I was on the bar course, the cost of the bar course was £16,000. And that is after an undergraduate degree, and often a law conversion course. And because coming to the bar is such a competitive career path, there are often other degrees taken on. So you can imagine the level of debt taken on. In terms of securing pupillage, it can sometimes take 2-3 years or more, sometimes up to 5 years. During that time, people will often take low-paid work in order to increase their experiences, improve their CVs, and they might continue to study. So the level of debt taken on by the time you start working as a junior criminal barrister is phenomenal. And then to come into this profession knowing that this is what you'll earn. It is often the case that people leave in the early years, and that means that we're left with an aging profession. I've just looked, and I think 45% of practicing criminal barristers are 45 years or older. So we are an aging profession, and we are losing talented people because it is simply not sustainable, especially if you think about the cost of living and inflation that has been going on. It is impossible to imagine people surviving. We have to spend most of our time working free. The life as a criminal pupil not only includes low pay, we often have to work Saturdays. For most criminal pupils, Saturday court is a given. I've spoken to my fellow pupils who say they haven't had a day off since they can remember, really, since starting pupillage. If you can imagine, we're also dealing with quite heavy subject matter, heavy emotionally. So if you are spending that day at the magistrates or the Crown Court, you are dealing with people who are traumatized and with very difficult things when you've had little rest and little pay. So the level of the risk for burnout is also very high. And diversity has been mentioned, and this is important because we're coming to have a situation where you can only be a criminal barrister if you can afford to. So if you have a wealthy family or financial backing, and that is simply unfair and unhelpful to the people we're representing. We're meant to represent society as a whole. And if we carry on in the direction that we're headed, that simply won't be possible. Thank you.
Thank you very much, Ruba. Panelists, my next question to you is, what are the objectives of this indefinite strike action? In other words, in your expert opinions, how could or should our criminal justice system be reformed to combat the issues that you have previously discussed? And Lucie, would you mind going first?
Well, the action is predicated on very clear ballot demands, which were settled by the membership and have been supported by, in the most recent ballot, just over 90% of the membership. So that gives you an idea of how unified the bar are on all of this. And the ballot demands are these: a 25% increase in pay, which sounds like an enormous amount, but when you're talking about incomes at the level that Ruba is presently experiencing, when you're talking about people who are earning around £12,000 in their first 3 years of practice, with only a steady incremental increase thereafter, that gives you some idea of how little 25% actually amounts to once you implement it. Secondly, implementation of the recommendations made in the Bellamy review, which were primarily around the sheer quantity of work that a criminal barrister will do and not be paid for. And so contrary to, I suppose, sort of the layperson's impression of our job, most of our work is not undertaken in court. It's undertaking preparing to go into court. It's reading the case papers, it's analysing the evidence, it's advising, it's drafting a basis of plea, a sentencing note, legal argument. The list is almost endless. And at the moment, an awful lot of that work simply goes unpaid altogether, so that the fees that we receive, if you break them down on an hourly basis, as other lawyers will do in other areas of practice, can amount to very little, which is one of the reasons that we lose barristers to other areas of law, because of course we're not competing to recruit against other sectors, we're competing to recruit young, talented barristers who have different types of practice available to them, civil and commercial. And so that's the second request. Thirdly, a pay review body, equivalent to the health sector, or other prison officers, other equivalent areas of the welfare state, where there is a year-on-year recommendation to deal primarily with the fact of inflation. At the moment, the criminal bar has to negotiate on almost an annual basis in this rather unseemly wrangle to try and make progress in relation to fees. And we want to try and formalise that and give it some kind of neutral body that we can start to conduct those effectively pay review negotiations through, in the way, for example, that the doctors or the nurses or the teachers do. And then finally, specific requests around particular fees for work in serious sexual offence cases, which are, without going into the detail of it all tonight, particularly poorly remunerated, be in light of the skill that is involved in undertaking that type of work, the number of hours that it requires. And the fact that the fees at the moment just really don't reflect the gravity of the work that is done. So those are the ballot demands, and that's what the membership are asking for, and that's what we put to government. Government at the moment are offering a 15% increase to be implemented at the end of this month, but what they're not doing is attaching it to what we call the backlog cases, so the almost 60,000 cases that are currently stuck in the system. The problem with that is that for barristers at Rupa's level of call, their diaries will be full of work for the next year, 18 months or so, particularly if their practice has cemented into a Crown Court practice. And so they're effectively another 18 months to 2 years away from receiving the pay increase. So how I often describe it is, if you were in the employed sector and your boss said to you, well, I'm giving you a pay increase, and you would say, that's great. And then they would say to you, but first of all, you've got to live through the cost of living crisis. You've got to live through the exponential increase in inflation. And I know 300 of you gave up last year because you were simply finding it too difficult. But if you can survive all of that for another 2 years, then you can have your pay increase. Somewhat inevitably, the membership of the Criminal Bar Association have said, well, no, I'm sorry, but that we really can't agree to those terms. That really isn't good enough. So first and foremost, it's putting the 15% on offer onto the backlog cases in order that people see a benefit immediately, so that we can retain, so that we can start to stem the recruitment and retention crisis that we're experiencing, in order to stabilise the profession and thereby stabilise the courts.
Thank you very much, Lucie. Ruba, I don't know if you have anything you'd like to add.
Well, Lucie has set it out very comprehensively, and I wholeheartedly agree with everything. I just want to say that there have been, suggestions of having a public defender's office similar to Crown Prosecution Service, but a defense service. But the reality of that is that it would be more costly to the government, because there is no way around it. People simply must be paid to do the work that we're doing. I would just echo those things. It needs to be a 25% pay rise, and that is the minimum, really, because the pay cut that we have witnessed in real terms to our pay is more than that. And just taking into account all the prep work, all of those things, I don't have much to add.
Thank you. That was no, I think you had an insight as well. Jo, I don't know if you have anything that you'd like to add at all.
I think most of the primary issues, as far as we're concerned, so far as our objectives are concerned, as the question states, Lucie's answered those. They are the crystallized demands that we have, which have been very carefully fashioned to reflect the changing economic landscape that all of us are operating within. And criminal barristers, who are citizens like everybody else, are fully conscious of the difficulties that people are experiencing more broadly in society. We have rent and mortgages to pay. We have food bills to pay. We have fuel costs. We have energy bills. We have all the things that everybody else has. And we, of course, are also acutely conscious of the fact that we are now heading very rapidly into hyperinflation. So inflation, which was predicted to be 9 and then 10%, now heading to 15%, which will eventually reach 18%. We're also very aware that other parts of the public sector, that's to say workers who are earning their income from government expenditure on behalf of the taxpayer, that other workers have made pay claims which are less than what we're asking for. And we're conscious of that because we know that other unions, or we're not a union, we're an association, but other representative bodies are doing their best to straddle a difficult task of asking for what is reasonable for their workers to earn in order to survive this cost of living crisis, and at the same time not putting such pressure upon the exchequer that it becomes an unreasonable demand. And in the course of us fashioning our objectives, because that's what the question was asking, we've been very careful to pitch it where we think is reasonable. So just to illustrate what Lucie was saying, a typical sentencing hearing would pay a barrister about £126 gross. Okay, now £126 gross is what they'd get paid for probably doing upwards of 8 to 10 hours of prep, traveling to court on their own cost, that's to say a train or driving to court, spending what could be a full day at court, which could be as much as 6 hours in court, traveling back home in the evening, and then getting on with the rest of their evening, which usually involves a lot more work for a criminal barrister. And they get paid for all of that, £126. They don't get paid for any written work that they've done for that hearing, even if the written work was commanded by a judge. A judge said, I want you to do this. You're not in a position to say, no, judge, I'm not going to do it. That, to us, is naked exploitation. There is no other word to describe it. It is using human beings to deliver a service at a rate of pay which is so far below minimum wage that it is tantamount to exploitation. And so that's why there is a stand being taken for these objectives, and we do not make any apology for saying that someone who's being paid £126 for all the work that I've just described, who gets a pay rise of 25%, which may take them up to, let's say, £50, £160, out of which they still got to pay tax. A lot of those people will still end up not only not making any money for a day's work, which is a hard day's work, but actually being out of pocket for their efforts. That's not acceptable. The reason why I said at the very beginning of this meeting, I'm very, very happy that the Sikh Human Rights Group has taken this on board, is because this is a human rights issue. It's about exploiting labor, particularly younger people who are not in a position at the criminal bar to stand up and say, I'm sorry, I'm not prepared to be used in that way. I'm not prepared for you to take advantage of my labor because I am in an asymmetrical power relationship where I can't say to a judge, I'm not a silk, I'm just a junior. If your honor says I have to do it, of course I'll stay up half the night to do it. That's not acceptable. And so, Carlos, just to answer the second part of the question, which was put in terms of reforms, we've got to have a criminal justice system in which the human beings who are representing clients and representing the state are treated with respect. If they're not treated with respect, and that is respect which is evidenced by not just what you're paid, but how you're treated, your working hours, what's been put upon you as additional work for which you're not being paid, all of those things are signs of disrespect. And that is, in effect, not treating our human rights properly, which is why when your organization has taken this up, I'm very pleased to see it as somebody from a Sikh background myself. This is to do with what Sikhs call seva. Seva ordinarily is not work that you do for remuneration, but what we are doing as barristers within the criminal justice system is continual and uninterrupted seva. We are doing things effectively, voluntarily, pro bono, because we're not being paid. Now, it's one thing if you are a member of a religious faith who chooses to give your free time freely for the sake of your wider community. That is admirable. It's something that all of us should be doing. But it should never be used as a device by government to avoid their own responsibility to make sure that not only you are paid properly, but the system that you are serving is funded properly. And this is why I have to say to you, our mission, our campaign, our action is not just about earning more money for ourselves so that we can survive. It's about reforming the wider system so it becomes a welcoming and sustainable place for new people to come into and stay within, and also something that this country that we're all proud of should be proud to hold up and say, that's the kind of justice system which reflects well on a modern industrial democracy, as Britain should be.
Thank you very much, Jo. I'll now turn to the next of our questions for the panellists. And we have touched upon it before, but it would be remiss of me not to ask your opinions on the impact that this indefinite strike action is having or is going to have on the victims of crime and those currently awaiting trial. In other words, we've heard a lot in the news recently that both victims and those charged with serious criminal offences are now going to have to wait for extended periods of time for their trials to begin. So therefore, my question to you is, do you believe that the intended positive outcomes of this indefinite strike action outweigh the distress and hardship that may be caused to the aforementioned parties? And Lucie, would you mind going first?
The short answer is yes, Carlos, and let me explain why I give an unequivocal yes. Because the options are binary. We don't take action and the system collapses, or we do take action. It has the regrettable consequence for the individuals presently caught up in it, that they will be impacted, and in some instances severely, in the hope of effecting change. And so for me, it was a relatively straightforward decision, okay, that I can either act in order to do right, or I can not act and continue to perpetrate a wrong. And so that's why I chose to act. How have we sought to ameliorate it? Well, we drafted guidance as an association, which gives back to what we call the vulnerability criteria. So what that means is that each individual barrister, precisely because we're not employed, is responsible for their own decision via each individual case. And so I, in company with all of my colleagues, have triaged our diaries in order to assess those cases where the harm that might be perpetrated against the individuals involved, whether they are particularly vulnerable defendants, complainants or witnesses, outweighs taking the action in that particular case. And wherever in our professional judgment, because just because we're taking action, it doesn't mean that we stop being barristers. So wherever in our professional judgment we gauge that the balance in an individual case tips in favour of continuing to attend at court, because bear in mind, we sometimes represent extremely vulnerable people. They may be suicidal, they may have health and mental health problems, there may be all kinds of issues in the background, then we will attend. Okay, so the first thing to say, it's not that we have ignored or negated or give no regard to the human rights of the people that we represent. But in terms of the action globally, of course, if it doesn't have an effect, it won't affect the change that needs to happen. And I'm quite clear in my own mind that by not acting, not only do we then effectively abandon the 60,000 cases and all of the human beings caught up in those to a constant perpetuation of the current delays, which are so harmful. I mean, particularly in sex cases now, people can literally wait years to get the case to trial, and the impact that it has on their mental health, whether as a complainant, particularly so, victim of violent offending, or indeed those accused of it who are remanded awaiting trial. The impacts are absolutely the cost. I don't think it's possible to quantify the human cost of what we're living through, which I think can only properly be described as systemic institutional failure. That's what we're dealing with. And so on a global scale, I think it's entirely right that we take the action that we do in order to try to stop the replication of the abuses which really are taking place at the moment. And that's an abuse of the right of all of us, but particularly the individuals, to be tried within a reasonable amount of time and to have the case disposed of, whether that results in a person's incarceration or freedom being a matter for the jury. But as I say, we have within that a safety valve, which to my mind protects the most vulnerable from the consequences of the action. What we've found is our barristers have deployed that safety valve in, as you would expect of the criminal bar, with enormous care and thought and consideration in order to protect the most vulnerable.
Thank you very much, Lucie. Ruba, I don't know if you have anything you'd like to add.
Absolutely. The first thing I want to say that the delays to the criminal justice system absolutely cannot be blamed on the action of barristers. those delays were there, and those delays are caused to victims and defendants alike. The action absolutely is exacerbating it, that's true. But the systematic failures already existed, and that's the system that we're working within. The other thing I want to start with is I'm really glad that Lucie mentioned vulnerability and the exceptions that we make, because of course as barristers we have duties, and we have duties to our clients, and before we consider a decision about taking an action, we consider the impact on those clients. And it's really important for people to be aware of that, because I'm not sure that that's something that is being reported on in the media, that there are exceptions to the strike, and we make those exceptions with good reason. I want to address the impact on victims firstly. I read today that for victims of domestic violence, they live in fear because they'll often have to wait maybe 3 years for their trials to go ahead. And in the meanwhile, while they may be in shelters in places that are unknown to the perpetrators, to the defendants then have time to research national charities and to try and locate them, which is a terrifying thought. So the people who the system exists to keep safe, they're being failed. The other thing is, of course, the most obvious example is victims of sexual offenses and rape. I think that at the moment, from going to the police with an allegation until trial, the wait time for a victim is something like 5 years. If you can imagine memories fading and the impact on the ability to have a fair trial when there have been such delays. For defendants themselves, many of them will have moved on with their lives or will be unable to move on with their lives because there is this giant unresolved matter. They may be unable to find work, or their circumstances may have changed completely by the time they are tried. The custody time limits expiring, I think that has been reported on recently, whereby some judges are refusing to extend custody time limits, which essentially means that people who may or may not be dangerous can no longer be held in custody pending their trials. So those are the very real impacts on victims and defendants. The other thing that I would point to is an overall loss of trust and confidence in the system as a whole. I think in the Secret Barristers book, they have written that people who have interacted with the criminal justice system as victims and complainants are less likely to ever bother again. So that means when people are victims of crime or witnesses of crime, they have no faith in the system and they won't bother reporting it. That just means a lawless society, and that is terrifying. We are witnessing a time of economic turmoil and massive disparity, which will inevitably mean a rise in crime. And considering that people will lose trust and confidence in the system is simply terrifying, because when people lose trust and confidence in the system, they also stop trying to hold it to account. During the pandemic, there was a rise in domestic violence as a whole, and we are still processing all the cases of domestic violence that were reported during the pandemic. So the impact for those people is staggering. The final thing is a two-tier justice system, which is what we're headed towards. At the moment, this is an unintended consequence of the strike, because of course another exception to the strike, because the strike is limited to legal aid funded defense work, that privately paid defense work goes ahead. That is not to say that people who pay privately for their representation are necessarily very wealthy people. The threshold for being eligible for legal aid is not incredibly high, and there are people who are not of great means, people who will have to go into debt to fund their legal costs, who have to pay privately. So those are the impacts to bear in mind. But again, they cannot be blamed solely on the strike. These things existed before. The strike is emphasizing them and exacerbating things. but this is the state of our criminal justice system.
Thank you very much, Ruba. Jo, over to you.
I agree with everything that both Ruba and Lucie have said. Just on that last point that Ruba mentioned, to drive this point home, we haven't created the problem for victims and defendants in the system. We've inherited that problem because of government negligence. And I'll put some flesh on the bones, if I may, with a few facts to help those who have been listening to understand why it's not our fault, as it were, that those victims and defendants are simply being left in abeyance. Between March of 2021 and March of 2022, over 1,000 criminal trials in this country had to be postponed at the 11th hour because there either wasn't a prosecutor or a defense advocate available to deal with that case. So you can imagine a victim coming to court, a defendant coming to court, maybe even in a prison van because they may have been remanded into custody, and then being told when they get to court, I'm very sorry, but your case isn't going ahead because we simply don't have a defense barrister or a prosecuting barrister available. And then being told to go away, possibly for months, if not another year, before they'll have their chance to come back to court again. Just imagine if you were a patient who was going in for surgery at your local hospital, and you thought that your surgery was scheduled to happen on a Monday, and you turned up dutifully, having had nil by mouth the night before, prepared yourself properly, and then you show up and they say to you, the surgeon who was going to do your operation, I'm afraid, is in another hospital because we don't have enough surgeons. We are undermanned, so you're going to have to come back in 6 months. How would you feel about that? These aren't problems that we've created. That's the first point. In fact, if you look at the number of trials that have been postponed well before the Criminal Bar Association ever carried out a ballot of its members, even in the first quarter of this year, there were 370 individual trials that were postponed. Of those 370 trials, 100 of them were cases of sexual offences and violence. So you can imagine how desperately vulnerable those particular potential victims were and were told to simply go away. And just another couple of figures. Lucie's mentioned that it could be years before, as a rape complainant, you ever get to see the inside of a court to have resolution of your case and the end to your nightmare. That is about in excess of 1,500 days from the time that the offence is committed to the time that it's sorted out at court. And if you're not in that sort of a case, but in any other type of case, it could be easily over 700 days. Can you imagine what it's like to live with the sword of Damocles over your head for years like that before you get justice in court? It's no surprise, therefore, that nearly half of rape complainants effectively give up before the case is resolved and walk away from a case. And that means the perpetrator may have got away with it and they're back on the streets. They walk away from the case because of the level of delays in the system. So that's a really important thing for people to have in mind when they consider, is this the Criminal Bar Association and the Criminal Bar which is causing the problem to victims and defendants? No, it's not. And as Ruba points out, it's right to say, however, of course, there is an impact of our strike. It's just obvious. You don't have a strike if you don't think it's going to have an impact. You don't have junior doctors balloting their members for a strike, or nurses doing the same, or train drivers who've already undertaken action and caused disruption to the public and inconvenience. They are doing it knowing full well that there will be an impact, collateral damage as it was, on people who didn't expect to be caught up in it. But those same people are being betrayed by a system of underfunding. It's not doctors or nurses who are delaying operations taking place. That's because there aren't enough doctors and nurses because the government simply hasn't done their job properly. And the same applies to our sector as well. So we make no apologies for it, but that doesn't mean we're being callous. We're very sensitive, as Lucie's pointed out, to the impact on people, and where we think the impact is so severe that it would be morally wrong and ethically wrong for us to stay on strike, and that we should instead go to court and deal with those cases, we do exactly that. But of course, you don't hear that reported in the media because it doesn't serve the government's narrative, which is one of that the criminal bar are betraying victims and innocent defendants, when in fact the government knows full well, the government's being quite hypocritical about this, they know full well that that responsibility lies at their door, as indeed does the solution. So if they want those same victims and defendants to have an easier life and be able to resolve this problem, then they should be ensuring that we can get back to work on a system of fair funding for the job that we do.
Thank you very much, Jo. Panellists, my final question to you is twofold. Firstly, how can members of our audience support you and your colleagues in your ongoing and highly commendable efforts to force through the reforms that are needed within our criminal justice system? And secondly, is there one message that you would like our audience to take away from today's discussion? And sticking to the current format, Lucie, would you mind going first?
Well, first and foremost, it's spreading the word. We have in recent months achieved something the criminal bar has never really achieved before, which is communicating to people what we do, that many of us are from ordinary backgrounds doing it, like myself, the importance of what we do, that it's not just defending criminals, as we've often been pilloried for in the past. We also prosecute the criminals and send them to prison. So we are the protection for the public. So I think the first thing that we would ask anyone on this meeting and watching this to do is to spread the word, to raise the importance of what it means to a democracy to have a functioning rule of law. We can't, as a so-called advanced nation, lecture the world about standards and the defence of human rights if we can't even implement them in our own backyard. And for as long as we're failing to do that, we have no right to take a stand on it in relation to anyone else. And given we have a long and proud history of really speaking for the effective participation, going back to your theme of all people in the society in order to make it the best society that we can, I think that has to be the most important thing we would ask anyone to do, to engage with the issue, to spread the word about the issue, and not just see this as an issue around the action right now. This isn't a temporary issue that's going to go away. If we want a functioning democracy, we have to take pride in the very institutions which give effect to that. And the rule of law is one of the most important. It's one of the most important protections that we have, that allows the individual to seek recourse against the state, or if the state is seeking recourse against the individual, for that to be done through a system that has fairness. And you need properly trained lawyers from all of our communities participating and being part of those systems, if those systems are going to have a humane and a fair face. So for those of you who are thinking about joining the criminal bar, come. For those of you already in the criminal bar, stay. And for those of you who are neither but want to support, spread the word of the importance. I suppose I would see it as a civic duty. In a more practical sense, and I'll leave Jo to speak to this, we do have a fund for those who would like to support those who are really struggling in the current action, but I'll hand over to Jo to speak to that.
Okay, so there is a hardship fund which has been set up by the Criminal Bar Association to help juniors, particularly juniors like Ruba, who are effectively starting out their careers and have the least amount in the way of savings and the highest amount in terms of student debt and other outgoings. So we want to ensure that if we are to be successful in this battle with government for justice for our members and for the broader system, we don't want to lose this battle because we're starved back to work. And all of the feedback that we've received from various quarters, including other parts of the bar, that's to say people who do work like commercial work, tax work, family work, employment work, people who generally earn more than criminal barristers do, has been quite surprising and incredibly reassuring to us that we have friends across the divide who are willing to support us. We've also had support from unions. We've also had support from solicitors. We've also had support from individual donors who have felt the need to support what we're doing because they've read about it in the paper and they genuinely feel sorry for our junior bar and the fact that they are subsisting on such low incomes. There is a link which I've posted on the chat. Please, those of you who wish to make a contribution, no matter how small, it may be just a small gesture of £5 or even £10, but in terms of your own conscience, I assume that people have attended this Zoom meeting tonight precisely because they have not just an interest in what's going on with this strike action, but there must be a degree of sympathy as well for what we are doing and support for our cause. And if anyone therefore feels moved to want to make a modest donation, then please do on the link that we've posted. So broadly speaking, from our perspective, if we have, and we think we have, spread a lot of publicity and increased the sum total of public knowledge about the state of the criminal justice system and the people who run it, then this has been a campaign which has been successful. We hope that that now filters through to wider civil society. We've had people from the doctor's profession coming to us and saying they believe in what we're doing. We've had others besides as well. All of them understand that the criminal bar is not operating in a silo. We are not flying solo. We are doing this as part of a wider movement of justice for people who are public sector workers. And therefore, we need a government that stops prioritizing the rich to ensure that the rich can enrich themselves even more, stop polarizing society so that the gap between rich and poor gets bigger and bigger, start prioritizing public services so that we can actually deliver for the public whose tax money we are spending after all, and for a government to have a conscience. And that's important, that not everything is about economics and treasury and finance. Sometimes there are moral things that need to be addressed, and the morality or immorality of leaving victims unattended and defendants languishing in custody whilst they await a trial that should have happened years ago is an immoral stain on our society. And we therefore beg government, please, to give this the attention it deserves, not least because government says it's concerned about law and order and about victims. Well, if they really are, then this is a good way to show it by coming to an agreement with the criminal bar so that we can go back to work and the public is served as they should be.
Thank you very much, Lucy. Thank you very much, Jo. Ruba, rightly so, I think. Would you like to have the final word of the scripted part of the agenda?
Thank you, Carlos. I think the things that people can do to support us, firstly, absolutely spread the word, keep the conversation going, and also lobby your local politicians, write to the government, participate in what's going on, and that's the best way you can support us. And of course, the Hardship Fund that Jo has posted the link to. The other thing is that people should do, and this is an important practice in general, is to consume media critically and to really think about what you're reading and what you're hearing in the media, because there are specific stereotypes about barristers. People look at barristers and they see highly educated people who have to wear suits for work. And the assumption is that we're wealthy or well paid. There is little understanding that we might be working for less than minimum wage and effectively in some cases paying for the privilege of working. So really read things carefully with a critical eye and listen to people from inside the profession. Junior barristers have been sharing their stories at protests, at demonstrations outside courts. People have been sharing how they've come to the bar and what it's like working at the bar. So listen to those stories and really understand from people who know and who've experienced it what it is actually like, and don't make assumptions and adopt the stereotypes. If there is one message that I would really like for people to have, and that is a general message about the criminal justice system, is that it is just as important as the NHS. It is vital and it affects everyone. People think about criminal justice often as something that doesn't touch their lives, that it wouldn't happen to me, it has nothing to do with me. Well, it doesn't until it does. Anyone can be a victim of crime, anyone can be accused of crime, and it is absolutely fundamental to a properly functioning society, a society that is democratic, a society that is safe, a society that has the rule of law. So if we don't invest in the criminal justice system, we lose what makes this country what it is, I would say. For years, the British justice system has had an impeccable reputation around the world. Justice systems have modeled themselves after it. It has impacted the entire world of law. And to lose that would just be staggering and tragic.
Thank you very much, Ruba. That now brings us to the end of the pre-prepared questions. I'm now going to pass over to my colleague, Ms. Bethan Walters, our Human Rights Communications and Media Officer, and she'll be taking the audience Q&A. So, Bethan, over to you.
Thank you, Carlos, and thank you so much to all of our speakers. They were incredible answers, all of them, and for someone who isn't as well versed in this, it was really informative. And I think for anyone who is in doubt of kind of why they should care so much about this, those doubts have hopefully completely gone. So yeah, as Carlos mentioned, we're going to open the floor up to questions. So you can either pop your hand up if you want to verbally ask it, or pop it in the chat. But we've got some questions that have been written in as well. So while people, I'm sure, are thinking of their best questions, I'll start with, again, whoever kind of feels they want to answer it first. But you mentioned obviously a lot about kind of how this system has got a massive impact on diversity within the justice system. But can you speak to, I guess, why diversity is so important when we are making these decisions in the justice system, and why the privileged, the people who can actually afford to be a barrister, although, like you said, it has a massive impact on their finances, shouldn't be the only ones who are representing us in the justice system, and actually how much of a difference it can make in decisions at the court, and why we really need diversity in a place like this. Open to anyone, really, I guess.
Lucie, Ruba, do you want to go on that one?
I can do, Jo, and then I know you will have much to contribute on it. Let me just take a worked example. David Lammy, approximately 5 years ago, reported on the racism that is entrenched in the criminal justice system. The fact that if you're black and coming into the criminal courts, the statistics indicate that you are likely to get worse outcomes, by which I mean you may well receive longer sentences, simply explained by race. And that is evidently wrong. The only aspect of the justice system that he singled out as seemingly not compromised in that way was the jury element, so acquittals and convictions delivered by juries. Now, why might that be? Well, one explanation might be that because when you bring a sufficiently large number of people into the decision making, and in juries historically we've always stuck with the number of 12, you balance out the biases and prejudices that individuals might have. And it would seem that that is likely the explanation for why that component of the justice system isn't compromised in the way that it seems that other aspects are. And those other aspects are self-evidently the lawyers who are either prosecuting or defending, so that would include me, and the judges who are passing sentence. So I think that's a worked example of why you can't run a fair system if it isn't a diverse system. The two things are integral, they're one and the same. If you don't have all of your communities participating in every single aspect of decision making, it will start to reflect biases and privilege. And we know that in every sector of society, whether we look at inequality in health outcomes, whether we look at inequality in education outcomes, or whether we look at inequality in criminal justice outcomes. So, Bethan, that would be my worked example of why it is absolutely imperative that we retain and promote diversity. And I know that Jo will now add and expand to that, because it's something that he too has done an enormous amount of work on over the years, speaking from his platform and using his position as a leader in our profession, which he is, and one of the foremost leaders in the criminal justice system, to try and affect change by being the voice of those of us who come from diverse backgrounds.
And just on the subject of us being from diverse backgrounds, you can see that you've invited 3 panelists today who in fact come from groups which are not traditionally associated with the English bar at all. So you've got Lucie, who is white working class from Yorkshire. You've got Ruba, who comes from another country, originally Ruba, if I remember rightly. And you've got myself, and I'm a guy who was born and brought up in Southall in West London, of Indian, Punjabi, Sikh stock. So these are the typical individuals that we see coming into the criminal bar these days, which is why the under 10 years call bracket, that's to say the relatively juniors at the criminal bar, are the most diverse cohort, which is why we are so alarmed about losing 40% of those people who are practicing crime last year, who have gone on to other areas of work, because that depletion of women and men from that junior end of the criminal bar will mean that the sort of people you'll get in the future representing clients and representing the state as prosecutors will revert back to what you would have expected to see 2, 3, 4 decades ago if you'd walked into an English courtroom. In other words, people who are white, people who are male, people who are middle class, people who are largely privately educated, people who largely went to Oxbridge, and people who come from families with money, as Ruba has pointed out. In other words, the sort of people for whom doing the job of being a criminal barrister is as much a hobby as it is a necessity. And this is why we have to be extremely careful about the effect of underfunding. It is all the unintended consequences. Ruba mentioned them in relation to victims. Look at the unintended consequences on diversity of not actually supporting criminal barristers through their careers by funding their wages properly. Now, I've done, as Lucie's mentioned, a lot of work over the years. I started off walking on demonstrations back in the mid-70s in Southall against the National Front, fighting against racists and fascists. I graduated from there as a teenager when I was at university working for the Southall Monitoring Group, which was again pledged to work against discrimination and the abuse of power by, for example, the police and the state. And throughout my university years, I'm sure that some of you who are on this call who are still at university will have been involved in societies and in campaigns. But throughout my years as well, my focus very much was on anti-racism. And what I have seen over these many decades of being involved in anti-racism, including at the bar, where I was vice chair of the Equality, Diversity and Social Mobility Committee for about 10 plus years, what I've seen is a lot of hard work which has produced dividends in terms of diversity, encouraging people from schools that were traditionally excluded as a source of new recruits into the bar. That's to say comprehensive schools like the one that I went to, that I know Lucie went to. These are state school educated children who would never imagined or dreamt that they could be barristers. But by personifying what a barrister is, people like ourselves are able to relate to those, and they're able to relate to us and say, that's a career for me. Now, if those people aren't able to enter this sector because they don't have the money, because they can't sustain themselves, or because they start with good intentions but leave within a year or two, that is a tragedy that is entirely foreseeable. And government cannot be let off the hook on this. Government, on the one hand, talks about levelling up, but at the same time, it's actually levelling down, and it's reverting to a 1950s type of criminal bar profession that really we should have seen off years and years ago. So this is, for me, two things: the intrinsic value of diversity, because it's actually intrinsically good to have people who are black, brown, women, minorities of every different protected characteristic within our family at the bar. Intrinsically a good thing. Extrinsically also good, because as Lucie's pointed out, when you have people from different diverse backgrounds in the system, there is less likelihood of that system going awry and producing discriminatory outcomes, because we are effectively the sentinels, the people who are watching the system from the inside to make sure it delivers in a non-discriminatory way. So from government's point of view, from society's point of view, and from our point of view as a profession, the virtues that we think attach to having a diverse cohort of women and men and people from all sorts of backgrounds is clear. It's self-evident, it's important, we must protect it, we must defend it. And if we start sliding back into a different age, all of us, not just criminal barristers, all of us have a shared responsibility to stand up and say, not in my name.
Thank you very, very much, both. That was, excellently answered. I know Dr. Jasdev Rai, our director, has got a question, and there's also one in the chat. So I'll pass over to Jasdev to ask a question next.
Hello. First, let me say thank you to Jo, Lucie, and Ruba for agreeing to come to our this webinar. And it's been, in a way, quite shocking to hear what you've said. And when Carlos first raised the issue with me, I found it a bit difficult to believe him. Yeah? And I tell you what, it has sort of some memories of the way junior doctors were treated at one time. Yeah, we were given not a completely poverty salary, but the amount of hours we were expected to work was about 100 hours a week sometimes, between 90 and 100 hours a week, but we weren't only paid for 40 hours a week. That was 40 years ago when I qualified and started medicine in this country. But about 2 decades ago, junior doctors and the BMA and the profession came together and put its foot down with the minimum hours and everything. It's much has changed since then, and it surprises me that the profession that's more or less dominates Parliament itself hasn't really looked after its own people. So I have 2 questions. One, I mean, given that Parliament has more or less more than 50, or if more than that, MPs are lawyers by background, is there any sympathy from them, any support from them? The second I have is a lot of human rights organizations, like for instance us, we had very good relations with lawyers for a long time because we used them. We used to champion a lot of cases, but our focus of the last 10 years has been mostly the UN. But how can organizations, NGOs who are dependent on lawyers really, how can we come together and help you, support you in this?
To start, Jo? Shall I start?
Yeah, I'm happy to go last on
Yes.
this. You and Ruba, by all means, and I'm happy to.
Just a thank you for your question, and again, thank you for hosting this. And we're so appreciative of the fact that the Sikh Human Rights Group have given us a platform. What a big question, where to start. Do we have support? Yes, we do. Cross-party, we do. Why do I think it's been difficult to translate that into political momentum? I think because it's that inevitable tension in relation to the work we do between doing the right thing and retaining the vote of the electorate. And as criminal lawyers, we obviously all too often sit in a position, particularly those of us defend, where the work that we do may be necessary and may be right and may be intrinsic to a functioning society, but it's very easy to miscaricature or indeed to caricature in the tabloid press. So I think that's something that we've really battled over the years to address, but which this year I think we finally managed to change the face of and change the momentum in relation to. But secondly, converting that into, I think, policy that reflects what is necessary is a link that has been broken over the course of the last 20 years. I think we've seen a situation whereby what would originally have been the old boys, the old white boys network of old white lawyers and old white parliamentarians having quite an effective lobbying situation, as we've made such great advances at the criminal bar to change our complexion and become more diverse, and as indeed the political parties themselves have changed, that's fallen away. But it hasn't yet been replaced in the way that your profession have done so effectively, with a really effective, professionalised lobbying, if I can put it that way, because we are a small profession. We are only 2,400. So relative, of course, to the BMA, which has paid officers, and is able to marshal really effective, and I've been watching them closely as the junior doctors gear up again, really effective political lobbying campaigns. We, to a degree, under Jo's remarkable leadership, and it has been absolutely remarkable. I've had to start from scratch to build that. So one of the things personally I would really like to see come out of the current action is a sort of an institutional knowledge of a profession, of how we now turn that into effective political liaison going forwards, because I think you're right to identify it's one of the things that we have lacked, because I'm not persuaded that when we articulate our arguments as we've done tonight, which are so evidently right and therefore consequently persuasive, that when we bring them to the political audience, they don't fall on deaf ears. Actually, they fall on very receptive ears. But to marshal that and leverage on it takes time. So I think we're at the beginning, and you're to point out that we're way behind. And one of the reasons we're way behind is because as a self-employed profession, it's been very difficult previously to turn a group of very disparate individuals into a unified movement. And again, under Jo's superb leadership, that has not come easily. That's been hard fought for and difficult to attain. Now we've got it. It's transposing it forward. To answer your second question, what would we seek from other lawyers in our profession? What can they bring to help us? Really, the two things are solidarity. So publicly standing behind us as one unified bar and being willing to say that we stand with our sisters and brothers in the criminal justice system and we support them. That is very powerful. And secondly, to the degree that they're able to, through their professional associations, particularly looking to the commercial and civil bar, where obviously incomes are so much higher, is practical support by way of contribution of donations, which so many of them have given, and we are enormously grateful for. And that helps both the morale of our very juniors like Ruba, but also assists them practically to sustain the necessary action.
Thank you. I'd like to add, so I think we absolutely do have support in Parliament, and there are politicians and members of Parliament who support our cause. But in terms of the government, that's not really reflected. I think there was mention of the fact that a lot of politicians are former barristers. Well, I think a lot of them were non-practicing. So they don't necessarily know what it's like. But also the criminal justice system is not a particularly attractive subject for the electorate. It's something that people like to distance themselves from, other than sort of vague promises to be tough on crime and, you know, things like being the party of law and order. And people fail to make the connection between that and, you know, actual conditions in the criminal justice system. I think also, sadly, barristers and lawyers are very easy to scapegoat and to even demonize. And I think there's a lot of alarming and harmful messaging that has actually come from people in the government, you know, judges being called enemies of the people, lawyers being called lefty lawyers. These are really dangerous things that can really undermine the work we're doing and also put us in physical risk. So that is, it's really disheartening to hear that from the government. I think that sometimes they can just get sort of a short-term win with populistic statements, because often there is antagonism towards barristers and towards lawyers, and it's a shame, really. I think in terms of the support from organizations like the Sikh Human Rights Group is really giving us a platform, as you've done today, which is fantastic. And you mentioned that you often work with barristers and are supported by barristers and you champion cases. So being really vocal in your messaging about that and the role that barristers play in supporting NGOs and human rights organizations is crucial. And diversity, I mean, that is the key. The one thing I think about, I go back to what Jo was saying, that we're a diverse panel and that we come from different backgrounds and not what people expect when they think of the English bar. I am an immigrant and I'm Palestinian, and when I prosecute and I say I act on behalf of the Crown, I act on behalf of the prosecution, I think that really means something, because when you are acting on behalf of the state should reflect everyone in the state. It isn't a particular person, and the more diverse it can be, the better.
Thank you very much for your answers. Jo, did you want to add anything?
Just to say, first of all, I agree with everything that's been said by Lucie and by Ruba. Look, Dr. Rai is absolutely right. It's a remarkable thing that you have a parliament stuffed full of lawyers, and yet you do not appear to have a reservoir of sympathy readily accessed by the bar when the bar is in trouble. And that's because, of course, the preoccupations for politicians are very different to what we do. We, as individual women and men who are doing this job, we get a case, we deal with that case, we do the best that we can on that case. We're not distracted by any other considerations. We don't have an electorate who are looking at us and wondering whether or not they should vote for us. There are no consequences to our actions which will rebound on us as long as we're doing our jobs professionally and competently. Politicians, of course, are subject to other pressures, and that's why they are far more responsive to the view that media takes. So, in fact, Dr. Wright, it's not so much parliamentarians that we are concerned about. Parliamentarians, of course, ultimately wield the power, but in particular, of course, the executive makes the decisions, and they are people that we have been prevailing upon, and we've been persuading them, and we've been pulling every lever we can to get them to see things from our point of view, and we've had an enormous amount of success in doing that, including holding events within Parliament for Lords and MPs to come along and hear what the issue is about so that they can lend us their support. So that's not been something that we've missed. We've focused on it in a very targeted fashion. The real challenge has been the media, because unlike your profession, Dr. Rai, where generally speaking, most people will have a favorable opinion of doctors and of nurses because they need them when they are vulnerable, and they need them to fix their problems and health issues and the rest of it, which is why when a few years ago there was this question of whether junior doctors might in fact go on strike, it was received with horror by the country because they thought, my goodness, they're going on strike, or they might do. It's a bit like the idea of police officers going on strike. Of course, legally, police officers can't go on strike. But when barristers talked about going on strike, there was this sense of, what, them? The ones who are earning all the money, the fat cat lawyers? How on earth can they have a valid complaint about earnings? Aren't they all driving Rolls Royces? Which, of course, was completely untrue, but which served a media narrative, which is that lawyers as a breed of people are all earning lots of money, and therefore they have no reason to complain. Let me tell you what my personal take is on why the media approach it in that way. And I've always been of the view that the media serve political interests. It's not that they operate in a vacuum. The reason why the media and elements of government have historically been extremely harsh on barristers, on criminal advocates in particular, is because we have a voice and we use it. We have the ability to marshal arguments and deploy them. We have the courage to stand up to the state and fight when we think it's appropriate to do so for the little person. And we're not inclined to back down. Now, if you are a government with authoritarian tendencies, the last thing you want within civil society is a band of professional women and men who have a habit of making trouble for you by actually using all the skills and talents and the voices that they can amass to speak against what they regard as injustice. And of course, it's not just me sitting here in Ealing addressing you, or Lucie somewhere else in the country, or Ruba somewhere else in the country as individual examples of barristers. There's a whole army of us out there. And what we've demonstrated in the course of this action is that we're not only capable of acting collectively and having solidarity, but we can make a lot of noise. And that noise draws the attention of the media, which means it then ends up on television and radio and in the newspapers. This makes for an uncomfortable situation for a government that would much rather we just shut up and went away. But we're not going to do that. So ironically, Dr. Rai, the fact that we are people who supply a sort of steady stream of entrance to Parliament, because people in Parliament do like the sounds of their own voices, the fact of the matter is once they're in Parliament, of course, they kick the ladder away. So it's our job to actually hold their feet to the fire and make them honor the commitments that they have to society and to us. And we will continue to make a noise, because the noise that we are making, we genuinely believe and profoundly believe actually is in the interests of wider society and the betterment of the public. So the takeaway for me, if you're looking for any takeaway, is use whatever you have at your disposal to do the right thing in society. If you have a voice, use it. If you are using your labor and you feel you're being exploited, withdraw it. If you're someone who is a doctor or a nurse who's helping sick people, don't be afraid to stand up for that system by sometimes saying, I'm sorry, I'm not going to carry on working like this. It's a matter of confidence amongst the public and amongst people who are serving the public to stand up to government and say, you're not doing the right thing, and we won't simply stand by whilst our society disintegrates. And what I genuinely believe the Sikh human rights organization and group are seeking to achieve is a positive improvement within society, where we work hard, we get paid for that work, but also we choose to do seva, to give our time freely and voluntarily as well as part of the third sector. So Dr. Rai, if you're looking for a way to close the circle so that people in the UN and in other places with NGOs can support what we're doing, just let them know that what we're doing is what they are doing. We're all trying to achieve the same thing. We're all trying to achieve human rights for individual citizens and justice for everyone.
Thank you. I think you all answered that excellently. I think probably important to address the last question in the chat, which might be a nice kind of final statement for you all, hopefully, to bring a little bit of light on this conversation. Is actually, why should young people who are in the position where they're choosing to go into criminal kind of barrister professions not be put off the idea now? And obviously you mentioned about, the need for diversity, but kind of where is the light at the end of the tunnel for them, and kind of what answers or what advice would you give them during this time? I don't know if, Lucie, you've answered it in the chat a little bit, so I don't know if you want to expand a bit more.
Yes, I've given an answer to Eleanor in the chat, and I'm glad, Bethan, that you've given us a chance to answer it directly. So Eleanor, speaking directly to you, when I was called to the bar in 2005, it was further to having been told in clear terms by the advisor at my university that the criminal bar wasn't for the likes of me. And I'm sorry to say I believed that for a period of time before it eventually dawned on me what a ridiculous thing it was that has been said to me. Now, of course, your concern is not only can I get to the criminal bar, but can I make a living from it? Well, the first thing to say is that it may be necessary in your early years to diversify precisely because of the problems that we've talked about tonight. But that is open to you to do, so don't allow that to deter you from coming to the bar. The second thing to say is that none of us do this for the money. So once you have persevered and got it to a level where you can survive, the privilege of representing someone in their darkest hour, and I do a defence-only practice, is almost impossible to convey. If you've never sat in a prison cell or sat in the cells of court with someone who has lost everything, and often by their own actions, and often because they're labouring under either psychiatric or other difficulties, which may or may not be of their own making, but which have flawed their life, and they may have done awful things. Many of my clients have done awful things. The privilege of sitting with a human being in those circumstances, when you are all that stands between them and the state, and ensuring that they're dealt with fairly, no matter what they've done, has been one of the, continues to be one of the things that I'm most proud about, that I've done with my life and done with my skills. So if you have an ability to speak for others, I do passionately believe that you have an obligation to then use it. And if that is you, Eleanor, you will find that, try as you might, you won't be able to avoid criminal law. It will find its way to you, even if you don't find its way to it, because that will be your destiny. That is what you will have been brought into the world to do. And the obstacles, therefore, won't defeat you. And to give you some hope, it's to say that there are people like me and Jo and Ruba, Jo particularly in terms of his sterling work over the last year, who have done everything that we can to ensure that we sustain this profession for you to come with us. So if it takes a little longer, if you have to do something else first, if you have to finance it in a different way, I would say to you without a shadow of a doubt, do it, because once you arrive and you join us, you won't regret it. Yes, it's hard, but it's a wonderful thing to do.
Eleanor, I want to speak to you because I've been in your position really recently. First of all, we're doing this now for you and for people like you because we need you. We cannot have an aging profession. There aren't enough criminal barristers. So if you want to do it, please do, and please don't give up. Second of all, I'll just echo what Lucie was saying. There is nothing you can do that is more rewarding and more fulfilling. I mean, we get into it because of the public service, because we want to work with people, because we want to help people, because we want to make sure that everyone has a fair trial, or if you're prosecuting, yes, that they have a fair trial, but the witnesses who are interacting with the criminal justice system have the best possible experience that they can under those dark circumstances, that you can sit next to someone who is facing maybe the worst thing in their life, and you can be on their side and you can support them through it. I don't think there is anything I would rather be doing, and despite the challenges, I don't think there is anything better. So I hope that you do come and do this and that you find your way here. And I hope that our action that we're taking now makes things easier for you and for people like you, so that in the future it isn't a question, and that we can attract the best and the brightest and the most capable people.
I think I'd wholeheartedly agree with what's been said by both Lucie and Ruba as to the virtues of doing this job. This is what I would add. I regard this question that Eleanor's raised, and Eleanor, it's often raised with us, those of us who spend time doing webinars talking to law students about the choices that they are about to make when they're standing at a crossroads and deciding whether they want to be a solicitor or a barrister. Those who come from non-law degree backgrounds who are going to do the conversion equally would want to know which is the best way to jump, solicitor or barrister, or neither. And I found myself on the horns of a dilemma over recent years, as I've noticed two particular things which have really coloured my thinking. One is truly the poor pay for the junior bar, which is a great deterrent to a lot of people, including yourself, Eleanor, as to whether they want to embark upon a journey that takes them to a criminal court as an advocate. The other is the level of intense competition over pupillage, which means that a lot of people who do the bar exams in the hope that they will get a pupillage end up disappointed. However, it's also fair to point out, as Ruba mentioned earlier, that sometimes it takes several years before you get yourself on the conveyor belt, before you land a pupillage, which of course is our apprenticeship and which you need to get in order to be able to move through the system. The average age of a criminal pupil these days is 29. And that tells its own story, Eleanor. That means that a lot of people out there who have been doing other things during their 20s, after they've done their academic qualifications, to improve their CVs, whether they're doing voluntary work or legally related work or other types of work, who eventually find their way to the criminal bar as mature adults who've got life experience and can make a decision. Now, I've always looked at this question of what do I say to somebody who, like Eleanor, who says, well, I'm not sure I want to do this because of all the problems you keep talking about, Jo. It makes me feel like I'm really put off. And I imagine a conversation with let's say, my niece, and my niece comes to me and says, I'm 19 years old. I'm in the second year at university doing a law degree. I'm not sure. Should I be a barrister like you? Or should I do something else? And in my mind, I'm thinking, yeah, I want you to be a barrister like me. And on the other side, I'm thinking, yeah, but you know, your chance of getting pupillage are not great. And your chance of making a viable career in the early years is not wonderful. But I also want to say to her, persevere, because of all the joys that you've just heard about from both Lucie and Ruba. In the end, this is a value judgment for you. There are three things that lawyers fight about in our courts in this country. Money. So if you're doing commercial work or personal injury work, you're talking about getting a settlement. You're talking about winning money for your client. Their children. When people are fighting in the family courts after the breakdown of a relationship, and they want to have access to their children. That's a big thing that people fight about. But the third thing that people fight about in this country is their liberty. And that's where we come in. And of all those three things, of course, children are extremely important to all of us. And yes, money does matter. But there is something quintessentially about liberty. that makes those of us who have committed to doing criminal work, either prosecuting or defending people in the system, feel that we're doing something exceptionally important for society. We are guarding the liberty of those who should not be sent to prison. Or if we're prosecuting, we're making sure that those who have done something seriously wrong should be deprived of their liberty, because that's the punishment they face in our jurisdiction. But it's an important currency within our country, liberty. And if you believe liberty is important, Eleanor, and anybody else out there who's contemplating a career at the bar, then think about why doing criminal work is so centrally important. And as Lucie has said, there are workarounds. You don't have to say, I'm going to dive in at the deep end and only be a criminal barrister. There are many chambers. Lucie's chambers, Garden Court, does other types of work apart from crime. So you could develop a hybrid practice in crime and family, crime and employment, crime and regulatory work, crime and public law. There are many happy partnerships that you could forge and still have a successful career. And at a later stage, once you've got yourself on a financially stable footing, because you've had a hybrid practice with more than one source of income, then you can make a commitment and say to yourself, all right, I've done all that. What I really, really love about the work that I do actually is criminal cases. I want to fight criminal cases and only those cases. Then you'll be in a position to increase the concentration of your work in criminal practice. So don't be put off, Eleanor. Don't be put off anyone. It's an amazing career. It will make you feel when you go to bed at night that you've done something really worthwhile, rather than just make a few extra hundreds or thousands of pounds for a privately paying client in commercial work. This stuff actually makes you feel like you are a citizen of this country doing something critically important for the health of the nation. And I'm not overplaying it, for the health of the nation, because justice is at the heart of everything we should be doing as a society. And if you're at the cutting edge of that as a criminal barrister, then you are making the change that you want to see.
Jo and everyone, thank you so much for that. And yeah, sorry for, I hope Eleanor, you do it now after those answers. But yeah, no, I think yeah, we have overrun a little bit, so I'll pass over to Carlos, but I do agree none of that could have gone unsaid. So thank you very much.
Thank you, Bethan. Yeah, I do apologise that we've gone slightly over time. I just have a few concluding remarks, and that's just to say to the members of the audience, thank you so much for attending today's discussions. I really hope you've enjoyed it as much as we have. And panellists, thank you so much for taking the time out of your evenings to be with us today. It's been truly wonderful having you on. Members of the audience, if you do have any other follow-up questions, then please do not hesitate to reach out to myself or my colleagues by visiting our website at shrg.ngo. Once again, thank you very much for attending, and I really hope that you all have a wonderful rest of the evening. That concludes today's event.